Hello and welcome. Today, we're diving deep into the very specific language of global data privacy. Now, for legal professionals like you, getting the distinctions right between different jurisdictions, well, it's not just about semantics, is it? It's absolutely fundamental to ensuring compliance, mitigating massive risks, and really providing effective counsel in a world where data is constantly crossing borders. So that brings us to the big question. How do you make sure your legal documents, your client advice, and even your internal policies use terminology that can stand up to the intense scrutiny of global regulations? That's exactly what we're going to tackle today, focusing on the specific, precise language that forms the bedrock of international data privacy law. All right, so here's our roadmap. We'll start with the big picture, the global legal framework. Then we'll zoom in on its two main pillars, the GDPR and the CCPA, and really compare them. After that, we'll build our core vocabulary, sharpen our grammar for legal arguments, and then finally, we'll put all those skills to the test with the complex debate around the right to be forgotten. First things first, before we can even begin to master the language, we have to understand the legal landscape it operates in. You know, this global framework is the foundation for everything else we're going to talk about. Yeah, we're dealing with this incredibly complex web of regulations where geography is almost fluid. Think about it. A client in one country can easily fall under the laws of another just by processing the data of its citizens. This interconnectedness makes having a shared, precise legal language absolutely critical for anyone practicing internationally. Now, while major laws have popped up in places like Brazil and Canada, our focus today is going to be on the two frameworks that have really set the global standard: Europe's GDPR and California's CCPA. Honestly, their influence is so huge that if you understand them, you're well on your way to navigating the entire international landscape. Okay, let's get into our comparative analysis. Knowing the specific differences in terminology and scope between GDPR and the CCPA isn't just a nice to have. It's fundamental if you want to give accurate legal advice to your international clients. And these distinctions are so critical. Just look at the terminology. GDPR calls them a data subject, while the CCPA says consumer. The right to erasure and the right to delete sound similar, but they actually come from different legal foundations. But here's the real game changer, the consent model. GDPR's opt-in by default is a totally different philosophy of privacy, and it puts a much higher compliance burden on companies than the CCPA's opt-out framework. Let's just zero in on this term for a second. Under GDPR, a data subject is an incredibly broad definition. It applies to literally any individual, doesn't matter what their citizenship is, whose data is processed while they are in the EU. So for a non-EU company, this means your website just being accessible in Europe could bring you under GDPR's massive extraterritorial reach. It's huge. Now compare that to the CCPA's consumer. It's more narrowly defined. It's a California resident. Now, you might think that sounds geographically limited, but don't be fooled. The sheer economic power of California means this definition impacts businesses all over the world. The key takeaway here is you have to know precisely who you're talking about under which law. And why does all this precision matter so much? Well, let's talk numbers. Under GDPR, if you're non-compliant, you could face fines of up to 20 million euros or 4% of your company's global annual turnover, whichever is higher. This number really shows that misinterpreting the legal language isn't just some academic mistake, it's a potentially catastrophic financial risk. Which brings us right to our core lexicon. Using these terms correctly isn't just about sounding professional, it's about accurately describing legal roles and responsibilities, and that has a direct impact on liability. First up, the controller. This is the primary decision maker. It's the entity that defines the why and the how of any data processing. In any legal analysis, identifying the controller is always step one, because the vast majority of legal responsibility and liability rests right here. The processor, on the other hand, acts on behalf of the controller. Think of a cloud provider or maybe a third-party analytics service. They handle data based on the controller's explicit legal instructions, which have to be laid out in a formal data processing agreement, or DPA. That distinction is legally vital. And what about a breach? It's not just a hack. Legally, it's any incident that compromises the confidentiality, integrity, or availability of personal data. That's a broad definition. It means even something as simple as sending an email to the wrong person could technically be a reportable breach. Understanding that nuance is key to fulfilling those mandatory notification obligations. So, having the right vocabulary is one thing, but structuring it with grammatical precision is a whole other level. This is where we eliminate any ambiguous phrasing and really build strong legal arguments. In legal communication, you often have to describe a state of adaptation. The phrase is not used to, followed by a verb with ing, the gerund, is a really precise tool. It lets you convey that an organization or a person is still adjusting to new legal requirements, but without implying they're incompetent. It's very professional. So let's try it out. How would you complete this sentence to indicate that the counsel is capable but still adapting? Our new legal counsel, blank, with the strict GDPR requirements. The correct structure is not used to working. See how that phrasing professionally conveys that the counsel isn't quite fully accustomed to the rigorous demands of GDPR yet? It's a very nuanced way to describe a very common professional situation. Now, let's talk about prepositions. I know, but in legal drafting, these little words have a massive impact. In usually describes a static condition or a location. Data is stored in a database, you act in compliance. Out, on the other hand, signifies movement or removal. Data is transferred out of a country. Using the wrong one can fundamentally change the meaning of a legal clause or misrepresent a security situation in a report. All right, let's put it all together now. We'll take the frameworks, the lexicon, and the grammar, and apply it all to a core legal debate that is still shaping our digital world. This is the big question. It's known formally as the right to erasure under GDPR, and this concept is incredibly powerful, but it's also deeply controversial. Is it truly essential for modern privacy? Let's break down the legal arguments. On one hand, proponents argue this right is absolutely fundamental for the autonomy of the data subject, and it aligns perfectly with that core GDPR principle of data minimization. But on the other side, opponents raise really serious concerns about conflicts with freedom of speech and the significant technical burdens this places on data controllers. They often argue that less absolute rights, like the right to correction, might be a more balanced solution. And that's where we'll end today, with this question for you. Using the precise language we've covered, considering the different obligations of controllers versus processors, and understanding the incredibly high stakes involved, how would you construct your argument? Which legal principles do you think hold more weight in this global context? The answer to that question is still being written in courtrooms and legislatures all around the world.